Everyone, and welcome back to a weekly live stream session of the KLSCAH webinar series. My name is 𝗖𝗍, and I'm your moderator for today's session. On February 19th, Malaysiakini was fined for 500,000 ringgit over comments posted on one of their articles published on their website. The news portal was charged with negligence over monitoring their online comments. In this current COVID-19 pandemic, the public's reliance on online media has risen sharply. With many conversations taking place online, Malaysiakini is one of the few news portals in the country that retains a comment section on their website, an important platform for discussions on public issues. Based on this case, will their charge of contempt be applicable to them? And what does this mean for online media freedom in Malaysia? Joining me today, we have three expert guests who will be discussing this case. Our first guest, Wathshlah Naidu, is Chief Executive of Center for Independent Journalism. Second guest, MP Sivarasa Rasiah, Senior Lawyer with expertise on the Constitution, our former Deputy Minister for Regional Development, who is also now serving as MP for Sungai Buloh. And last but not least, Mr. Stephen Gunn, our Editor-in-Chief and co-founder of Malaysiakini. I would like to first say also a big thank you to our media partner for today, Malaysiakini. You can view this webinar session live on both Kini TV and our Facebook page at KLSCAH. And now I would like to invite our first panelist, Wathshlah, to share her views on our topic today. Wathshlah, over to you.
Thank you very much, 𝗖𝗍, and a very good evening to everyone. I'm quite happy to be here. Well, technically, I wish I didn't have to be here, but since the situation is such, I'm here really to talk about the impact of the recent Malaysiakini judgment on freedom of development and as well as media freedom in Malaysia. So basically, I'll be providing a snapshot. I'll be focusing on three sequential points. The first is to look at our discussions on the current freedom of expression landscape, and this is pre-Malaysiakini decision. Second, I'll look at the Malaysiakini decision and its impact on freedom of expression in Malaysia. And finally, how do we move forward now post-Malaysiakini, and what's our future? What's the future of our freedom of expression? Now, looking at the situation before the Malaysiakini decision and just the timeline of within the past 1 year, what we've seen is after the Sheraton move, and of course, with the pandemic, it's almost like the current government's been given an uphill task, yeah? And all their action seems to denote that there's such levels of incompetencies, and it's almost like they've gone into war with wooden swords and now literally battling for survival. Yeah, and as such, the trend within the last year has been a move by the PN government to essentially silence any dissenting voices, or to crack down against those who question their authority or action. And within the last year, we've seen, just from the start of their rule, we've seen human rights defenders, starting with Swadya. We've seen opposition politicians being investigated and being called in. Now, with the media, of course, we have seen journalists and news portals being investigated by the police, as well as being charged with criminal offenses for their reporting. Now, we are also seeing a situation where media operations in Malaysia are more controlled and they're more restricted now more than ever, especially since the change of government, right? So the decision of the court with regards to the Malaysiakini case comes at a time where the government is going all out, cracking down on those challenging or questioning the regime, right? To give you a few examples of how media has been media is experiencing crackdown over the last year. We've seen how the Defense Minister, Ismail Sabri, attacked Channel News Asia senior correspondent over a story on foreign workers, right? We've also seen South China Morning Post reporter who was summoned for questioning for an article that was on the government's raid on migrants in Kuala Lumpur. We've also seen health news portal Code editor-in-chief, who was summoned by the police for over her articles written in 2019, right? And then, of course, we've seen the incidents with Al Jazeera and how they were being investigated for their documentary. And then finally, now we're seeing the decision with regards to Malaysiakini. All that also points is to the fact that the current government has backtracked on the reform agenda, particularly those related to freedom of expression and media freedom. They failed in their in the previous commitments made under the PH manifesto, which was to review and amend or repeal laws that stifle our freedoms, particularly freedom of expression. Yeah. Now, in these attempts to silence dissenting voices, we are increasingly seeing certain repressive and very, very archaic laws being used. There's an increase in the use of the Sedition Act. There's an increase in the use of the Communications and Multimedia Act, Section 233, which is so broad and vague in the way it makes it an offense for any person who knowingly make or solicit communications which is deemed as obscene, indecent, false, or menacing, with the intent to annoy, abuse, threaten. I'm still trying to figure out how they're trying to define annoy. Yeah, we've also seen how the existence of other laws such as the Printing Presses and Publications Act and the Official Secrets Act, it's like almost like a sword hanging over the heads of media in the way they report as well. Now, there's also an increase in the use of certain penal code provisions, particularly in relation to Section 499 on defamation, on 504, which is on intentional insult with intent to provoke a breach of the peace, and 545 statements conducing to public mischief. We've also seen ministers threatening to use Section 203A of the Penal Code, which makes it an offense for those who disclose any unauthorized dissemination of information that they obtain through the performance of their duty. Yeah. And finally, now we see the use of Section 114A of the Evidence Act. And the 2012 amendments basically makes internet user now as liable, as they are deemed as publishers of any online content unless it's proven otherwise, because there's a presumption of fact, right? So as in the case of Malaysiakini, it makes then any individuals or those who administer, operate, or provide the necessary spaces or platform now liable for contents published through their services. So now it looks as if, even pre-Malaysiakini's decision, the situation was already very, very challenging. Yeah. Now, if we look then at the Malaysiakini decision and its impact on freedom of expression in Malaysia, it's quite evident, the direct impact, of course, Stephen will discuss later in terms of this, the impact on the comments and on the media generally. But, the direct impact on media is there's now increasing need for them to introduce more regulatory measures, yeah, to moderate comments. And in moderating comments, you're basically expecting then the media to act as a censorship board, because you're indirectly censoring speech and people's expression. Now, and it's also, in the event you get 2,000 to 5,000 comments a day, it's a very, very costly affair. And the media now is already experiencing such financial challenges, and the sustainability of media is already being challenged. And this is going to add more to the cost of operation. Yeah. And if media then moves towards either removing the comment section because of this fear that they would continue to be held liable for third-party comments, this would then in turn impact our own democracy, because in a participatory democracy, we as the citizens, as the voters, have the right to challenge and debate on any issues. Yeah. Aside from seriously undermining the role of media in facilitating the space, we now are not just losing the space, but increasingly, of course, also continuing to experience restrictions and crackdowns where our participation is limited because our ideas, our opinions are no longer possible to be exchanged, right? Through platforms provided by media. And as such, matters of public interest then cannot be freely debated on, or we can't even protest on matters which are generally fundamental to us. And Article 10 of the Federal Constitution provides for our rights, or recognizes our rights to freedom of expression and freedom of speech. But this decision now has a huge likelihood to impact the spaces and the platform for us now to exchange these ideas. It's also very troubling to see how certain approaches have been adopted through this decision, and this would continue to have impact on the way we are also critical of the various branches of the government, yeah. Or the state, sorry, the various branches of the state and the different institutions of the state. It's the legislative, the executive, and the judiciary. I refer to a paper written by a well-known lawyer, which basically challenges the very discouraging way that archive approaches to legal doctrines of scandalizing the court has been applied here. Yeah. It's important for us as public to know that we should also be given the space to be critical about the judiciary, and now with the restrictions being placed, or with the fear of being cited now for further contempt, we will start then also self-censoring ourselves, as well as losing our spaces to make these comments and make our opinions heard. Yeah. So it's also, I just want to touch to the way this decision is also set a precedent where Section 114A has been invoked. This creates again additional fear that we could possibly be held liable for comments online. Yeah. Now these particular amendment was already criticized for being very, very highly controversial when it was introduced in 2012. Yeah, especially for its overreach, the way it makes internet intermediaries liable for content, yeah, that is published through their services. So this presumption of fact places an added burden on users, on media, which facilitates these comments and discussions. Yeah. Now, I would like to focus, at a little bit on the third point, which is really about what is really going to be our future of freedom of expression in Malaysia, and how do we move forward post this Malaysiakini judgment and its implication on our freedoms here. I guess in a very, very simplistic way, just to say that we would have to continue claiming our spaces and voices. The reform agenda might be forgotten by the current government, but we as public cannot and should not forget this reform agenda. Yeah, because as long as these laws continues to exist, and the institutions that allows these laws to exist, it's going to continue to stifle our rights, especially our freedom of expression. So we need to, aside from claiming our spaces, we need to continue with the way we demand these spaces. Yeah. And I want to also note that it's also really important in this context, how do we see the need to regulate media and the way these laws are being used to regulate media? It's a very dangerous and slippery road that we are on now. And that's why I think we really need to push for a media council here in Malaysia, which would be an independent self-regulatory body, which would not just provide the code to be upheld by the media, but it will also provide the avenues, for arbitration of any complaints against the media. So in situations such as what was seen by Malaysiakini, I mean, would the existence of a media council have changed or provided a different avenue? I would like to think so, but I think to do that, we need to move towards a government that would establish an independent body such as a media council, which will also enable that entities such as the media council to operate independently. And finally, I just want to say that, and then this is a general call really to all branches of the state, that public confidence can only be fostered through public criticism and debate, and not by suppressing democratic dissent. So the danger that the state is failing to realize is that it's continuing to undermine its own stature and credibility through the use of very repressive applications of the current laws and legal practices, because this is likely to just continue provoking discontent and rather than bolstering the status of public institutions. So on that note, I would say that the situation may seem grim, but as public and as citizens, we do have a key role to play. And how do we push forward in ensuring that our rights, especially rights contained within our federal constitution, Article 10, is realized, and how do we claim our spaces and our voices? Thank you.
Thank you, Wathshlah. Now I would like to invite our next panelist, 𝗕PC𝗲𝗏. 𝗕PC𝗲𝗏, passing the floor to you.
Thank you very much. Yi, can you hear me?
All good.
Good. Okay. First of all, can I start by thanking Selangor Chinese Assembly Hall for this invitation to join this forum tonight, and also to Malaysiakini as a partner of this event. And hello to all my panelists, and also to all the listeners who are following our discussion out there. Now, let me just declare my interest also. I happen to own a few shares of Malaysiakini, so, but I can assure you that that doesn't color the views that I'm going to express tonight. For Wathshlah's info, I've actually been charged under Section 233 of the Multimedia and Communications Act. The case was withdrawn also under sedition. And as a lawyer handling a case for 𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗪𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔𝗔 in the case, but which luckily the judge didn't agree with and dismissed the application. So those experiences, of course, may shape and color my view somewhat, but I will try to be objective as much as I can. Yeah. Okay. In my time, in the time allocated to me, with the moderator's permission, I'm going to focus more on the judgment itself, to explain to our listeners what exactly is being said in the judgment, and touch also on the impact of the judgment, because some aspects of the judgment can be a little technical. And just to clarify the concept of contempt of court and the role of intention, in contempt and so on. And in the case of the narrow issue in 𝗖cie𝗂𝗿𝗁, which is what happens when third parties or readers post comments which are clearly in contempt, but which the host of the platform, like 𝗖cie𝗂𝗿𝗁, has absolutely no knowledge about. So that is really the narrower issue that we're dealing with. And unfortunately, the majority judgment has decided that the host, like Malaysiakini, is liable, which is a very serious development in that sense. So we start with the premise. There are 7 judges who heard this case in the federal court. 6 wrote a majority judgment, and Justice Nalini wrote a dissenting minority judgment. And I'm going to say from the beginning, I find her judgment to be the better judgment, in the sense that I think it strikes a better balance between the 2 interests we are talking about, which is protecting the integrity of the court and also protecting freedom of expression. I think she has found the better balance. Now, the facts are quite clear. The facts are clear from the judgment. There were 4 comments which were listed in the majority judgment of readers, I think mostly anonymous readers, posting quite strong comments about the judiciary. I think there's no dispute about the fact that those comments are clearly in contempt of court because they allege corruption. They mention the Chief Justice's name specifically, and so on. I think that part is not disputed by anybody. The comments are in contempt. Now, before we go further, let me just explain again contempt of court in a very brief way. There's such a thing called civil contempt. There's such a thing called criminal contempt. Now, civil contempt is like things when you breach a court order or you try to evade service of a court process and so on. What we are discussing today in Malaysiakini's case is criminal contempt, which means the accusation against the contemptor, the person who commits the contempt, is that you scandalized the judiciary, you eroded the public confidence in the judiciary, you attacked the integrity of the judiciary and so on. So when one makes comments that the judge or judges or the institution is riddled with corruption, or judges are corrupt, judges are biased in their ruling, or you use language like they are fools and idiots, it has happened in other countries and so on. These are the examples that are treated as criminal contempt. They are treated like criminal cases. So the standard of proof is quite high, it's beyond reasonable doubt. And of course, the penalties also involve jail and fines and so on. The tolerance for such comments on the judiciary varies from country to country. For example, in UK, the British press has, for example, when the editors disagreed with a particular judgment of the House of Lords or some very high court, they published the faces of the judges upside down, and they had one word on the front page headline. It said "fools." But in the context in Britain, they said, well, people can criticize. The judiciary did not respond. It carried on doing its job. So it varies from place to place. Judges here tend to look at local circumstances and so on. So now, so back to the judgment. As Wathshlah just told us, 114A of the Evidence Act came into play for the first time. Basically, what 114A does is it makes the publisher of the comments, or rather like the host, for example, in 𝗖cie𝗂𝗿𝗁, it deems them publishers. So somebody else writes the comment, but you are deemed to be the publisher. And it's a presumption. It's what in law we call a presumption. A fact is deemed about it. So here it's deemed that you published, but you can rebut the presumption. So, but it is quite oppressive because, as Wathshlah explained, it affects internet freedom of expression, and it really limits the freedom to publish on the internet. And it's the first time now we're coming to grips with the case. So let me summarize now what the majority said and what the minority, Justice Nalini, said, so we can see the different approaches. What the majority said is this: Malaysiakini is deemed to be the publisher, first premise, using 114A. Now, then they go on to say Malaysiakini intended to publish the contemptuous remarks. That's going quite far. They actually intended it, although it is actually undisputable on the facts that 𝗖cie𝗂𝗿𝗁 did not know at all about the comments until the existence of the comments was brought to their attention. And it's also undisputed fact that the moment 𝗖cie𝗂𝗿𝗁 knew about the comments, it removed the comments immediately within 12 minutes. Yeah. So, but as far as the majority is concerned, they went on to use this concept of constructive knowledge, which means because of the way the filtering system or the scrutinizing system for comments is set up, 𝗖cie𝗂𝗿𝗁 had knowledge of the comments and also had intention, therefore, to publish the offending comments, which is really going very, very far. And based on that, they found 𝗖cie𝗂𝗿𝗁 guilty of contempt and then the fine of 5,000. Although the Aegis Chambers who brought the application in the first place actually proposed a fine of 200,000 to the court. But somehow the court seemed to want to send a signal that it treated it more seriously and fined 500,000. Justice Nalini's reasoning is quite different. She accepts the presumption, which means she says, yes, 114A does make, on the face of it, basically the publisher, but she found the presumption was rebutted. In other words, her premise is to publish, you must have intention. You must know what you publish. If you don't know what you publish, you can't have the intention. It is pretty logical, it's pretty clear. I can't be in contempt of court, according to her, if I don't know about the words I'm supposed to have said. And that was basically clear arguments, which unfortunately the majority did not agree. And as far as Justice Nalini is concerned, it's like a fiction you're creating, a fiction of intention. And for a serious offense like criminal contempt of court, you can't do that sort of thing, And she disagreed with that. So she disagreed that the presumption was, she held it was rebutted. There was no intention on the part of 𝗖cie𝗂𝗿𝗁, and 𝗖cie𝗂𝗂𝗁 took down the comments immediately. To be fair, let me just make this comment before I go on. To be fair to the majority judgment, that because it's a majority, that reflects, of course, that is now the law of the land, yeah? Justice Nalini's reasoning, the law she expounds there is not the law of the land. That we must realize, yeah? It's a majority judgment, that's the law of the land. And also, unfortunately, in some other countries, some courts at various levels are also thinking in similar way of reasoning. So this is a controversy that is not just in Malaysia, it has happened in other judiciaries. And but at the same time, let me say this, Justice Nalini had no problem dealing with that. She says she's looked at all the different case laws all over the world. But as far as she was concerned, the issue is settled in Malaysia. Why? Because Parliament has legislated. So, and what the legislation she was talking about is the Multimedia and Communications Act, 1998. And there is a code which is made pursuant to that act. Yeah. And she says, when you look at the act and you look at all the provisions of the code, it is quite clear that's a complete answer to 𝗖cie𝗂𝗿𝗁's predicament. And what was her answer? Is this, that when the Multimedia and Communications Act was passed and when the code was done, it's very clear Malaysia has taken, insofar as these kind of issues, which is when third-party comments are posted on a host or platform like 𝗖cie𝗂𝗿𝗁 or other platforms, the approach taken is flag and take down. Not do like what the majority said, oh, you ought to have known about it and you knew, therefore it was there and therefore you intended the publication. They don't go that way. Parliament has legislated through the act and through the code that the correct process is first to flag. In other words, the host or the provider must be told about the existence of the content of the remarks first, whether they're defamatory or whether they're contentious. Then 2 working days is given for the host to notify the person who posted, remove them. And then another 24 hours if the person doesn't remove them, then the host can remove after that. Or in fact, the host can even remove it immediately, which is what 𝗖ście𝗂𝗿𝗁 did. So the Act provides, the laws made by Parliament provide 3 days for that process. And by then, 𝗖ście𝗂𝗂𝗿𝗁 or the host make the decision, I remove, or I don't remove, and I face the consequences. So here, on the facts which are not disputed, basically, the moment it was brought to the attention that these contemptuous remarks are on your website, within 12 minutes, it was removed. So this is what the technology says, they comply. And the Act says, the Multimedia and Communications Act also says, when there is compliance with the code, it's a complete defense to any kind of prosecution, civil or criminal or otherwise. So for her, she did not have to enter into a debate, oh, the Australian court said this, or the European court said that, because as far as she was concerned, Malaysian Parliament has legislated for this. And so my criticism of the majority judgment is basically to say, I think they misdirected themselves, which is kind of legally for saying they got it wrong. You know, they applied the wrong law. And where if I looking at the summary of the majority judgment that has been given to the public, we don't have the full judgments of both. We have summaries of the majority and the minority. The majority does not deal with this point about Parliament, about the laws. I mean, the MCA, the Multimedia and Communications Act, the provisions of the code, they're silent. So I interpret it as, I think they know there's a problem there. It is hard to match those provisions with the doctrine which they have created, which is intention can be imputed to 𝗖ście𝗂𝗿𝗁, although they have no knowledge whatsoever. So this is, I mean, a kind of a fairly simplified explanation of the judgment, the majority judgment and the minority. Unfortunately, because it's a majority judgment, 6 judges versus 1, as I said earlier, it's the law of the land. And although for me, in a way, it contradicts the laws passed by Parliament. So, because the impact, I think, has been described by Wathshlah. What it basically means now is hosts or platform providers like 𝗖ście𝗂𝗂𝗿𝗁 and similar platforms have to scrutinize every single comment and make a decision whether that comment stays or goes, which is really an impossible burden for many small-scale publishers, websites, and so on. Everybody's Facebook page, I mean, every politician runs a Facebook page, many prominent people, and many people post comments. Now it's all open now. Everybody is kind of liable if you take this reasoning through for the comments on their pages, and that cannot be right. Facebook and Twitter all operate through a flag and take down approach, which for me seems to be the best and the most logical and fair way of dealing with the problem. So now, either the host, like what Wathshlah said, you have to create a huge department to investigate or to check every comment, or you take down the comment section. And this is going to be a very retrogressive step. It's a backward step. The internet of the 20 years or 30 years of internet development have created a whole vigorous, really an environment for better freedom of expression, vigorous discussion of public issues, public interest issues, public policy and so on. Although, of course, there are abuses, there's no two ways about it. And in the law itself, in the Multimedia and Communications Act, there is a written commitment in Section 3 that there will be no censorship of the internet. So it's right there as the policy of the Act. And ironically, you now have a High Court, a Federal Court judgment, which is the highest court of the land, which represents the law, that creates virtually or creates an environment where people now must censor the host, the platform. In other words, you have to remove things. You have to check every comment and remove it, or close the section completely. So the space that we have developed, this is how the world progresses. You create more freedom, more discussions. If there are abuses, you find systems and ways to deal with the abuse, like, for example, the flag and take down approach. But with this judgment, we've gone backward. And how are we going to deal with it? Well, the one remedy is back to Parliament. Parliament provided a very reasonable system that works, but now which is in jeopardy because of this judgment. So it may be open, Parliament has to respond. But I think being realistic about things, given the current political situation, let's not hold our breaths and wait for that response. So we have to sit this out and wait for a different political, a new political era where the powers that be around the country are more respectful of freedom of expression, whose political will to protect freedom of expression is there, and who will make the necessary changes to resurrect and reinstate back the flag and take down position. And in the meantime, I can only wish my friend Stephen Gunn the best of luck in what he intends to do. We will of course hear from him. The system, I didn't go too much in detail about the system used to filter comments and so on, but both judgments do discuss the system you have installed, the way there's some limited scrutiny of the comments through your software called Talk, but you're the expert on that to talk about that. So yeah, I think that'll be fine for my opening comments. I hope that has helped give a clear idea of the judgment proper, and maybe later we can take questions and answer them. Thank you very much, Lee.
Thank you, MP Siva. Next, I would like to invite our third panelist, Mr. Stephen Gunn. Stephen Gunn, over to you.
Thank you, 𝗖𝗍. Thank you. Siva was one of the very first, one of the very few. When we first set up Malaysiakini, was one of the very first supporter of Malaysiakini. We got a few of them supporting Malaysiakini, putting in, chipping in a bit of money. But at that time, he was a human rights lawyer. He wasn't a politician then. If actually, in another court case, the fact that he hold shares in Malaysiakini was raised, and we had to, we told the judge that, look, Siva, the share was only 0.001% of the shares in Malaysia, of all the shares in Malaysiakini. But it's, we appreciate that very much. The fact that, he's been one of the pioneering supporters of Malaysiakini, and despite the fact that there is now a politician, we would want him to continue, having that stake, and I think it is a source of just to show that we respect the views of everybody, and that we will remain independent despite whoever our shareholders are. Okay, I also would like to thank the audience. I think many of you may have contributed to the Malaysiakini Legal Defense Fund. Thank you very much. I think I was shocked, by the response. I thought that it would take us a little bit longer than that to raise $500,000 ringgit. Given the fact that we were given 3 working days to pay the fine, we knew that it was a bit of a put us in a bit of a quandary there. But really happy that that somehow we're able to raise it within hours. So thank you very much for your support. It's something that that we really appreciate on behalf of Malaysiakini. Now, the role of the media is not only, as everybody knows, it's not only to provide news and information, but it's also, I think, it's something that is not emphasized enough, but it's also providing a platform for discussion on issues of public interest. Now, if you look at traditional media organization, you have, the opinion page, where you have politicians, experts, NGO activists writing, the pieces as part of a discussion, the debate on issues. But it shouldn't be confined to them also. Really, I think these are fair enough. These are experts and all that. But also, I think it should also involve the person on the street, and also again in traditional media, they have the letters to the editors, and I think this is a way for them to open up that discussion space to the to the lay person as well, so that at least you get everyone get to have a say in when it comes to matters of of public interest. And I think this somehow has changed to a certain extent, because with the internet, I think and the nature of the internet is such that sometimes you really get the real-time discussion that can be problematic to the point that many media organizations just basically give up. They say, look, we cannot moderate all this discussion, and you can see that they have conceded that public discussion space to the social media. They just basically shut down their comment section. You can see, there are quite a number of media organizations out there are not offering, a comment section for the readers. Partly because I think they are scared of perhaps something that had happened to Malaysiakini, or perhaps the comments are just too rude, sometimes too crude, and it would just take them the tremendous amount of effort and time to have to remove them. But I think Malaysiakini believes that they has to defend this public discussion space. I think if not, we'll surrender that space to the social media. And as you know how it is in social media, discussion will be, crude, inane, banal, and I think, fair enough, that has always been, that is the nature of the social media. And it is something that we are still grappling with in terms of how we're going to promote, proper discussion rather than just basically people trolling and spamming and attacking each other without really bothering to listen and argue their points in a civil manner. So I think that is definitely a problem. But I believe that while Malaysiakini does have a share of some of this pretty crass comments and all that, but I believe I think many of our comments are well thought out, they are well written and well argued, and I think definitely the public discussion space, the comment section in Malaysiakini, the quality of discussion is better than the social media, and I think we need to protect that. We cannot allow a few of the of those the commenters that are a little bit more trigger happy to spoil and poison the well, so to speak, of a space that we need to protect, that we value really. I think given that and given the court decision and all that, we have two choices. One is pre-moderation, and the other one is, as I say, complete suspension of the comment section. Now, as a lot of media organization has come to the realization, and that's the reason why they decided to suspend the comment section, is the cost of pre-moderation will be quite prohibitive. Really, I think it's only media organization like New York Times and all that, or perhaps Guardian. These are big multinationals. are able to hire a team of people to have a system of pre-moderation. With Malaysiakini, it's going to be very, very costly. And on top of that, the comments are posted 24/7. I mean, someone could post a comment at 3 or 4 o'clock in the morning, really. I think, which means that you really need to have, the moderators to be on alert at all times. And also, I think, comments can be posted any day, even years after the story has been published. Like, say, for instance, a person who happens to do a search in Google and come across a Malaysiakini story that was published, say, for instance, 10 years ago, whatever, and decided to comment on it, that is going to be, very hard for us to punt out, to moderate, because you have, it's going to be, we need to be, to be able to go back, 10 years, 20 years, whatever it is, how many stories that you have. And also, some of the comments are posted in stories that you will not expect that you're going to get problematic comments. The one that got us into trouble was, it's a pretty innocuous story. It was, basically the Chief Justice announcing that we are back in business, because when the MCO, the first MCO was more or less, come to an end. Unfortunately, it was made on when we published that story, which is just basically an announcement and say that, the court will be reopening and all that. Unfortunately, on that same day, the Attorney General has dropped charges against the former Sabah Chief Minister, Musa Aman. So, while we were expecting that there may be problematic comments in the Musa Aman story, we didn't realize that, at the same time, with this innocuous story of a Chief Justice making this announcement, that, somehow people tend to, put 2 and 2 together and have, and came up with 5 or 6. While, as I said, there may be some misunderstanding among some of the commenters that it was the Attorney General who actually dropped the charges, and it wasn't the judiciary that that is responsible for the dropping of charges. And some of our commenters unfortunately attacked the judiciary over that. So again, we need to be alert of all the different stories. And sometimes, stories that you think would not attract, certain problematic comments, it may, we may somehow it will fall under, under our radar. So I think it's really difficult. I think, and I guess, you may have try better algorithm or better AI, for instance. Again, it's not easy. It is costly. I mean, it's only, again, big companies can afford to have that kind of the AI to be able to pinpoint the nuances. Because if you've got a pretty stupid AI, it's going to ban a lot of comments, or maybe it will not be able to pick up certain comments. Our AI is not very sophisticated. It's just basically pinpointing some words that may be problematic, and beyond that, it cannot tell, whether this particular comment is a contempt of court. And I think, to be able to develop a system, you would need pretty good engineers. And I don't think we're able to do that. We can afford that kind of system. So there's an option, and we are looking into that for Malaysiakini. As I said, we are not going to suspend our comment pages, because otherwise that will be conceding to allowing basically we are surrendering to the social media. One option that we are looking at is to implement a two-tier system of commenters. One is the, tier 1 will be the pre-approved commenters, while tier 2 will be, those who are not pre-approved. Now, pre-approved commenters are, the commenters that we have already done perhaps, done some checking to make sure, we know them. These are people who have been posting comments for quite some time. They have a track record of being, responsible commenters and all that. So as soon, for those who are in tier 1, they're able to actually post the comments real time. So which means that as when they post it, it will go immediately. It will not be moderated. And I think, it is perhaps, there is a way for us to perhaps to allow that real time discussion, which is important. That's the nature of the internet. And for those who are in tier 2, commenters, of course, these are the people that we're not sure. They will have to go through pre-moderation. We may have to hire a few more moderators, and they will have to do a bit more, work in going through these comments, their comments, before we publish them. So I think, through that, perhaps they're able to somehow mitigate the problems that we had faced. It is not the best solution, and it may it may still create problems because someone may have posted even the tier 1 commenters may have posted something that may be problematic. But I think this is perhaps the best way for us to provide a balance between our right to freedom of speech and the many restrictive laws that we have in Malaysia. It is, as I said, you'll still get Malaysiakini into trouble. But I think it's perhaps we are reducing that risk to a point that we think is manageable. So it's perhaps a risk that we have to take. It's a risk that is worth taking, and it's a risk that we must be willing to take to defend our public space, where we provide a platform for Malaysians to come together and discuss issues. And I think that's really, really important, because Malaysia is multiracial, multicultural, multilingual and all that. We are so divided. There's imperative that Malaysians have a platform, a proper platform to discuss issues of public interest, in the hope that we can hopefully make compromises and to come to some consensus. And if not, at least agree to disagree. And I think that is really, really important. So we as Malaysians need to continue talking, because if we stop talking among ourselves, problems will start. So I think it is really, really important that media organizations like Malaysiakini should defend that public space to allow the proper discussion on all these issues. And these are really the issues that Malaysia must resolve if we are to move forward. Because if you're going to leave public discussion to social media, we are not going to be able to move forward. That is quite clear. Thank you very much.
Thank you, Mr. Stephen. So I would like to begin with the next session, the Q&A section. Before we begin, I would like to invite our viewers to give us continuous support by donating to KLSCAH, so that we can bring you more meaningful webinars like this. So thank you for, if you're viewing our webinar tonight, thank you very much. And we hope to receive your support in the future talks. So I would like to begin with the Q&A session. The first question we have tonight is, Okay. I have read articles of Sinchu daily writer Tay Tian Yen, and he uses opinions from senior journalist Gobind Rundra, unlike from opinions from social media like Facebook on Twitter. So my question is the media supposed to take responsibility for the comments of their readers, or are the readers supposed to take the responsibility? For this question, I would like to pass on to Wathshlah to answer.
Thank you, 𝗖𝗍. I think, thank you for the question. It's somewhat a double-edged sword. I think we've discussed earlier the role of media and the measures or certain measures that media can adopt in moderating these comments, right? Now, there is also a very, very fine line here, okay? By overly moderating or even taking down comments, you are at risk of censoring speech and censoring a person's freedom of expression. And we want to avoid this at all costs, because it's freedom of expression and freedom of speech is a fundamental constitutional right here. And as a public and as a citizen, we must always protect this particular right, because the moment this right's been taken away, our democracy basically completely falls apart. Yeah. So by saying that we expect media to moderate or to moderate to such an extent where they even have to scrutinize everything that is being said, that's being commented, it continues then to limit our freedom, right? Now, looking at what the decision expects the media to do is, of course, to moderate and censor before publishing. Yeah, what's currently in practice, and this is even globally challenged in terms of flag and take down approach. It is also seen in some instances as censoring, yeah, and limiting our expression. But I think what we need to also note is, when we say freedom of expression, it's not necessarily an absolute thing, right? There are grounds both under international law, particularly our Universal Declaration of Human Rights, and even our Federal Constitution, Article 10, which provides for certain grounds to restrict it, yeah? And these are often seen in instances of national security or public disorder and things like that. But the key element here to any kind of restriction has to be absolutely necessary, and the action will have to be proportionate. Yeah. So the question we ask here is, in censoring, was it necessary? In actions to take it down, was it proportionate to what was being said? Yeah. Now, the other element so the role of media here, I would say, given all the developments in Malaysia, yes, there is a need or a requirement to figure out how now we need to adapt to these requirements. Yeah, without overly censoring our right to speech. Now, what about the role of us as users? This is also very, very tricky, because as readers, as users, we have rights to express ourselves, our opinion, and and we look to different platforms to provide us a space to express ourselves. But we also have to be very cautious in how these could be perceived under certain restrictive laws in Malaysia. I don't want to caution anyone, and stop anyone from expressing themselves, but we need to be very cognizant of what's in our laws as well. Yeah, and hate speech, speech that threatens harm, violence, these are things that are considered as speech that could be restricted in certain jurisdiction, even international law. So the flip side to this now is if we use laws such as the Evidence Act, for example, which now Section 114A places the added burden on not just you as a user, yeah, because imagine if you have an account, you have a Facebook account or you have a Twitter account, right? And and it's connected on your devices, yeah, all your devices. And somebody gets hold of your phone or your tablet and is posting a message that may be seen as amounting to hate speech, for example, and you load it to that particular person for whatever reason, a friend, for example, who tweets using your phone, but accidentally, because your account, say for example, your Twitter account's open, you have not logged out your ID or your password, or your Facebook accounts, and he or she accidentally posts it on your Twitter, you can actually be held liable in the event somebody says, hey, this is defamation, this is an attack, yeah. So you can actually be held liable. The same way when bloggers or forum administrators have opens up these spaces. So and then suddenly somebody comes up with a comment that could be seen as being seditious under our law, then you can also be held liable. So this is the risk here. So on one hand, we do not want the media to overly regulate. On the other hand, we also need to be very cautious on some of the harms that could befall not just the media, but also us as users. So a lot of this now requires more, I would say we need to review these laws again. Yeah, and we need to get this amended or repealed. So actually, as what YB Siva actually mentioned earlier, we really need Parliament to resume. There's a lot of things on its agenda that needs to move forward.
Okay, thank you, Wathshlah.
Say something very quickly on that.
Go ahead.
No, I think the question is, the reader is asking it, basically saying, is the media institution responsible, or is the reader, the person who posted the comment, responsible, right? Was that the question? Yeah, basically. But let's not forget the question is being asked in the context of online publication, media publication. Online media, where the media institution itself has no control because the comment is being posted directly. There is a inability to moderate unless they take the policy of moderating. This difficulty does not arise for print publication, because print, the very nature of print is the editors will scrutinize every letter, every article. So if some very contemptuous article is written, of course they will read it and they won't publish it. So there is some sort of self-censorship, whatever it is, in the interest of the institution. So I think for me personally, the question is answered by saying, yes, the media, it is the reader first who should be responsible for its content, and it take responsibility for it, whether it's defamatory or contempt or whatever, contempt of God. But the media institution will only be responsible if it is told about it, I think the flag principle, and it doesn't take it down. That means it still wants to go on with the comment. I think that's when the responsibility then shifts also, not just the reader, the guy who posted it, but also to the media institution. Just very in brief.
Okay, right. Thank you, MP Siva. Mr. Stephen, do you have anything to add?
No, it's all right.
Okay. I will move on to the next question. So in follow-up to that question, should there be an expiration date or some kind of limit to comments existing on social media or online? I would like to open the floor to anyone who would like to answer.
Can I go first?
Yeah, go ahead, Mr. Stephen.
I think Siva has mentioned about the Communication and Multimedia Act. when that was passed in 1998, I think, or 1999, around that time, there were, at that time was, a lot of talk about internet censorship. And when the law was passed, it take cognizance of the fact that the law should not be seen, the CMA should not be seen as allowing internet censorship, that it should support, the freedom of speech. And that is why you have a content code, a code, under that act, which, is a mechanism where they have this flag and take down policy. And that is why, the platform providers are given 2 days to take down, any errant, to inform the commenters to remove the, a particular errant content, and then another 24 hours if that, the commenter did not respond, that the platform providers are empowered to remove it themselves, or they may decide that, that they do not even need to consult the commenters because the content, the comment was way, too offensive or whatever it is. They can decide to take it down. So I think, the law is there already, really, to have 2 days, 3 days, so I, as what Siva mentioned, apparently this was not taken into account by the majority decision. We're still waiting for the full judgment and see how they're going to, how they argue this particular defense that we actually, there's one of our key defense when we argue that in court. That look, there's, under CMA and under the law that was passed by Parliament, that, we have this system, this mechanism, so it's basically, unfortunately, it's rejected by the majority opinion. And as what Siva said, really, I think, within that law, CMA, if you comply to that, meaning that if you've been alerted and you decided to take down the particular errant comment, then you can use it as a defense in court, and that is what the minority opinion of that Malaysiakini contempt judgment have argued, that Malaysiakini has, acted in compliance with the code by removing, very quickly within 12 minutes, and therefore we were not in contempt.
Okay, thank you, Mr. Stephen. Does Wathshlah and Ms. MP Siva have anything to add?
Stephen has covered it quite thoroughly. I mean, it's translated.
Okay. Okay, to the next question. This is targeted towards Malaysiakini. What about the idea of disabling all comments for news reports? For this reader, they often read that most of the comments are redundant or overreacting and can be used as against the company in court or anyone in court. So therefore, why not just disable the comments section?
Yeah, that would be the easy way out, really. I mean, we can just suspend comments and then, and then we'll just move on, really. I think, but I don't think I really, I believe that, as I said, earlier, that is, we are just giving up one of the major role of a media organization, which is providing a platform for people to come together and discuss issues. I know that, the nature of the internet is such that, definitely you have quite inane comments, and you got the trollers and spammers and all that. It is, surprisingly, it is just like I have friends who are really polite when you get to know them, face to face and all that. But then when they are behind, when they are behind the wheel, it is some of them turn into a monster. Really, I think it's the anonymity that provides them that somehow that shield, and then they lose all form of all sort of civility. And I think that somehow explain some of the crude comments that we get in social media, because when you are behind the computer screen, then you are anonymous and people cannot see you face to face. You have that kind of problems. With Malaysiakini, we want to have we've been trying very hard to build a community of commenters. We're trying to have commenters to get to know each other and to build that community, because we believe that it is important. And there are a lot of expert commenters out there. Whatever stories I report on, some of them actually know more than us, because they're expert in certain areas, and they do provide interesting comments. And often that enriches, the public space. So I think it is important. We cannot allow, a few of these, errant commenters to poison the well. We have to, as I said, we have to protect that public space. We cannot concede, to social media. It is one of the very few ways that we hope, that we're able to build a platform where you have really vibrant, responsible, and interesting, well-argued comments, and hopefully through that we're able to to understand each other better, to be able to improve, to be able to contribute to the marketplace of ideas. Really, that's always been my idea, and I'm not going to give up that idea. I know that we do get a lot of people complaining about some of the comments made. We are doing our very best to try to weed out some of the problematic comments, and we'll continue to do so. We have to invest a little bit more money into that. Definitely, it is we are a small company and all that. We do not have that much money, but I think it would come to the point where we would need to invest a bit more money into that to ensure that the comment section remains, and so that that it would be of help to the public discussion on issue of interest to everybody in Malaysia.
Okay. And I guess to follow up on that, so when it comes to moderating these comments, is it required to employ much more people to moderate these comments then?
Yeah, right now we are only one one full-time, and the rest are all part-timers. People who just go through comments every now and then if need be. But I think we need a couple more full-timers to be able to go through. But when we implement that two-tier system, hopefully that would reduce the number of comments, that the need for us to really go through all the comments, because by taking out the tier 1 commenters, we can focus on the tier 2 commenters, the comments that's made by the tier 2 commenters. So we see we are experimenting. I think in light of the federal court decision, we got no other choice. We have to look at alternatives, and this is one idea that has been proposed. We'll see how we can make sure that we do not get into the kind of problems that we got into last week.
Okay. Thank you, Mr. Stephen. Oh, okay, go ahead, MP Siva.
What Stephen has said, I think this way I want to point out the unfairness to a smaller media institution like Malaysiakini. When you consider that the giant establishments like who operate platforms, Facebook, Twitter, and so on, they're subjected to this. They are only subjected to the what I see as a more universal standard of flagging and taking down. And taking down also, for them, it's a complex process. It's not simple. Just because somebody draws their attention to an offensive, defamatory or contemptuous comment doesn't mean they automatically take it down. They have a process, an appeal process and all that. But if they find it is systematically abused, then of course they will act. So for example, you have this well-known example of Trump, President Trump being removed or banned from Twitter. Of course, some people criticize it as an infringement of his freedom of expression, but when he's regularly inciting hatred, racial hatred or hatred, violence and so on, Twitter drew the line and banned him. So when such huge institutions with huge resources operating by that standard, Malaysiakini in Malaysia seems to be set a standard which is hugely burdensome, and they have used software to try to remove what we call lewd comments, vulgar comments, and so on. But as Stephen said, artificial intelligence cannot make sense of like the words that are in contempt here. It is very difficult for even sometimes lawyers to argue its contempt, and trying to get a software, with artificial intelligence to read it and say this is in contempt is virtually impossible. Which is why you need real eyes, actual eyes on the article, on the comments, and which is also very prohibitively costly. So, but the point I just want to stress is the unfairness of the standards. That and of course the far-reaching consequences, which I think already has been explained.
Okay, right. Thank you, MP Siva. Wathshlah, would you like to add anything on employing more resources or AI to moderate comments and so forth?
Yeah. Yes. But before that, I just want to acknowledge how much I appreciate Stephen's commitment and Malaysiakini's commitments to retain the comments, because I think what is really fundamental to us is the fact that media is the fourth pillar of democracy. It has a really important key function in facilitating a healthy public, basically, that's able to voice its opinion. Yeah. And with the advent of technology and social media, there are many platforms that has or facilitates comments. But the importance of media such as news portals and independent news portals are really still key towards ensuring that we have the most reliable, timely, and responsible reporting of news, that really reflects our realities, and we should be able to engage in that space. I just wanted to stress that. And the issue, the real issue that we are facing, in as much as it's now gone down to the level of Malaysiakini, it is really what is our current landscape on freedom of expression and speech. Yeah. And what is our current political social landscape that continues to use repressive laws to just silence people, through whichever means. In this instance, it's Malaysiakini. We never know at which point, these various laws are also going to, increasingly censor our speech in platforms like Facebook, Twitter, and other social media platforms, right? So we have to be very, very cautious with regards to that. Now, on the question of AI, there's always two ways of looking at it. We've also been very critical of, say, of Facebook, for example, of how it adopts an AI system of flagging and taking down comments on its platform on the basis of its own community standards, right? There's been a lot of criticism of how it's been very slow, it's been ineffective in taking down comments which which could even amount to hate and online attacks, online violence, particularly gender-based violence, so that there are many criticism. And as AI, as what was mentioned earlier, it's not a sure proof, because it works on a particular algorithm that you set at a particular time and point, right? Context changes, nuances changes, and people's interpretation of a particular word changes. Yeah, I was just having a conversation a few days ago of how, Pondan or Matnya, for example, about 40, 50 years ago was so common and acceptable, right? But you say that openly now, it has got a completely different connotation. So AI is never a sure proof, yeah, of being able to take note and correct these situations. Yeah, so it is one way of doing it, but ultimately what it's going to result in is more resources being put in place at a time where not only are we experiencing economic crisis, but a time where media in itself is struggling to survive. Yeah, so an added burden on the media, but and a rather, I would still say, an unnecessary burden at this point in time, because it's a burden that's pointing towards limiting our own rights. So, I mean, it's very difficult. As I said, some people will say, strengthen your AI, work with your developers, think of the nuances, think of the different languages, but you'll never find a system that's going to address all the differences in terms of our vernacular and our interpretation of particular words.
Thank you, Wathshlah. So next question. This is for all panelists. What are the silver linings from this? How can we get better? And for all stakeholders on this contempt of court charge.
If I may.
If
I may. Yeah.
Yeah, go ahead.
Just a really short one, I want to say, right? The immediate thing that we saw was the result of the fundraising initiative by Malaysiakini. Yeah. The fact that within 4 or 5 hours, Malaysiakini not only managed to meet its target, but it was above what was the target, showed that the message from the public is very clear. We are not, and it's a form of protest, I would say, yeah. We are not going to sit back and allow, Malaysiakini or media to face such attacks. Yeah, we general public's very supportive, and I think they see the critical role played by news portals or online news portals like Malaysiakini. For me, that is the biggest silver lining. So whatever was the justification or the basis for that decision was balanced by the outcry and the outrage by the public, and protests can come in different forms. And after more than a year, it's really heartwarming to see this level of protest from the public and this level of support from the public.
Okay. MP Siva, you would like to add something?
Well, yeah. I'm trying hard to find a silver lining. Well, I think I agree completely with Wathshlah. That's the one silver lining, at least, where spontaneous surge of support from the public. So the public made it very clear where their sympathies lay, and were prepared to put their money where their mouths were, and pay for the fine. And I think we all must continue to support Malaysiakini in their commitment to maintain the comment section with some modifications, but as a matter of principle, to keep open the space for public discussion and dialogue as a media, as an online newspaper portal, so that it's not like a traditional print media where it's more or less like a one-way street. Now, I earlier mentioned Parliament can correct these things. Yes, that's possible in a different political era. And but I also should mention that it's also open to the judiciary itself. I mean, in other words, another federal court. It needs another federal court to reverse this current federal court, to reverse and create a new approach, or maybe change back the approach to agree with the minority judgment. So that's possible. I don't think it's likely, but it's another possibility. So we hope, and I mean, but for me, the other small silver lining is the minority judgment. I mean, I think we must give due credit to the judge that that judgment, I think, reflects a fairly, judges balance competing interests. It's very common in a number of cases, especially in public interest cases. There's no one overriding interest. Usually different interests compete. And it's the difficult and intellectually challenging task for a judge to try to find the best balance, reasonable balance, given the circumstances. So I think in that sense, the dissenting judgment is like a beacon of light, which hopefully will influence and guide future judgment and future judicial thinking on this.
Okay, thank you, MP Siva. Stephen, would you like to add anything?
Yeah, the silver lining is that thank God it wasn't 7-0. I think the good thing was that at least you got two sides, to the argument. Though of course the minority opinion is just one, but at least you can still, people can compare, choose, read, and decide for themselves, regarding the arguments on this particular issue. And the differences between the two, the minority and the majority opinion is almost night and day. So I think people can decide for themselves. I think the other silver lining, I wouldn't say it's a silver lining, but I think also it also pinpoint and hopefully encourage that commenters should how to put it, should understand that they shouldn't. It's already, the environment is pretty toxic already. You look at our political environment, quite toxic. The identity politics has been played today. The politics of grievances and all that is quite toxic. And I don't think I think our Malaysian and the commenters out there should add to that toxicity. I think we should be better than some of the politicians out there. We should be doing better. In that sense, I think there's a need for Malaysian to rise up to that occasion. That when it comes to discussing issue, let's do that in civility. That let's be kind to each other. Let's be let's talk to each other and not talk over each other in that sense. Listen more and post comments in a way that that hopefully will encourage discussion and debate rather than being perceived as basically taking down or attacking the comments or the opinions of the people that you perceive as your enemies. or the other side. So I think it's important because at the end of the day, we are still a democracy. The last time I checked, of course, we know that Parliament is not being, just been suspended. We have an emergency and all that. But I think, if we really value the things that we have, it is important that we come together and really, to show to the politicians, and I don't mean all, but there's quite a lot of them that we are better than them, that we can actually come up with solutions, that we shouldn't allow them to set the agenda, and a toxic agenda at that. So I think I think that's a silver lining in some ways to remind all of us that, look, let's work on this, because at the end, really, I believe that if we're going to move forward, there is no one community who can take all, who should win all. I think there has to be certain give and take. So in that sense, to reach that stage, we really have to understand each other. I know it's quite utopian, but I believe in it. Because otherwise, I would not be, with Malaysiakini for 21 years. Then I think, then I could see that things, imagine 21 years ago, really, at a time when, people are scared to discuss issues. When they talk about when they discuss, issue of corruption or issue of abuse of power in the kopitiam and all that, they'll be looking, over the shoulder just to check whether there's any special branch or someone who look, like special branch around before they, talk about all these issues and discuss them. So I think, that is not the case anymore. I think, you got taxi drivers or your Grab driver would, sometimes, express their opinion quite strongly. So I think that we have overcome that fear, and it is, and I'm very positive that we can overcome. So in that sense, yeah, that's a silver lining. That at the end of the day, really, if we come together and debate and discuss issues, protect that space that we have, we would be able to hopefully, find, bring about solutions to the problems that we face.
Mm-hmm. Okay, thank you, Mr. Stephen. And I just want to add another question to what you have said about to generate a healthy conversation online. Do you think people will learn to be more civil online and censure others who aren't? Will we get better at agreeing to disagreeing civility?
You're talking to me?
Yes. Yeah.
Sorry. I believe so. I think when we have a public discussion, say for instance in a town hall, when everybody is there in a forum, whatever it is, you can see the discussion can be quite civil. When you see people face to face, you tend to moderate yourself. No matter how angry you are. So I think that's not the case when you're behind the computers, unfortunately. And I think people should to understand that it should be the case that whether you are facing somebody face to face or whether you are behind the computer. So in that sense, I think it'd be good if we can somehow adopt that attitude, and with that, hopefully we will have proper discussion and discussion that will actually move us forward as a country, rather than degenerate into people attacking each other, and at the end of the day, really create the kind of toxicity that we have today.
Okay, thank you. Wathshlah, would you like to add anything on?
Not really. Yeah.
Okay. MP Siva?
Just very quickly, I think Stephen is correct. The context for face-to-face conversation, discussion in a town hall, for example, people will generally be civil and all that. But there is a unique feature about online communication, which is the anonymity of it and the shield of the computer with a screen in front of you. And I don't know how much that will change. So I'm not as optimistic as Stephen in that sense. I think the reality of online comment will always have that amount of extreme, provocative, rude comments and so on. I think institutions, like, okay, take myself as a politician. If I started worrying about every offensive comment about myself, that's it. I will collapse of the stress in 20 minutes, or because all over social media, in news portals, there are disparaging comments. Sivarasa is a fool. Sivarasa is a political opportunist. I've never seen him for 5 years in my Kawasan. It's normal, I even some, so I think that's going to be the nature of the world, and we just have to live with that. There has to be, of course, when it gets extreme, then there has to be a system to manage it, and I think that's happening. That's the nature of the evolution of mechanisms in the internet to manage the internet and so on. But that psychological fact of the difference of the online environment compared to the physical environment, I think I really don't know how that will change, to create the awareness that you have to be civil and so on. So yeah, but I think we just have to get used to it, and keep developing the mechanisms so that the more extreme versions at least get dealt with, which also then encourage people to find the more civil, create a bigger civil space where people will learn to be more civil. I just may not be as optimistic as Stephen about it.
Okay, yeah, thank you, 𝗖cie this is a question for you, 𝗖cie. There is a trend by the courts to limit criticism of the judiciary. We've had Justice Hamid Sultan case. We had the case where Hanif Khatri and 2-3 others were fined for delaying implementation of court order. And now the Malaysiakini case. Is it time to codify the law of contempt?
Yeah, codification of the law of contempt has been an ongoing issue. There needs to be I would agree, there needs to be a more thorough, comprehensive law on contempt. But again, each case, like in a lot of legal cases, each case must be looked at on its own facts. So if somebody is violating a court order blatantly, intentionally, if somebody is deliberately avoiding service of a court process, for me, those are contempts, and we have to deal with it. Those are the civil contempts I mentioned earlier. It's the criminal contempt area where the judiciary reacts to protect in the name of protecting itself. That's where things get more complicated. And I actually have a paragraph. I was going to read it later, but maybe now is the right time to read it. This is a paragraph from a judgment of the Constitutional Court of South Africa, and they quote Chief Justice from India. His name is Chief Justice Rajendra Gadkar of the Indian Supreme Court. It was delivered sometime in the 60s. But this paragraph, I think, sums it up. And if I just may read it, it'll only take me a minute or so. So this is what he says about the power of contempt. And this is addressing it to his brother and sister judges all over the world, or judiciary as a whole, as a reminder to them. So this is what he says. We ought never to forget that the power to punish for contempt, large as it is, must always be exercised cautiously, wisely, and with circumspection. Frequent or indiscriminate use of this power in anger or in irritation will not help to sustain the dignity or status of the court, but may sometimes affect it adversely. Wise judges never forget that the best way to sustain the dignity and status of their office is to deserve respect from the public at large by the quality of their judgments, the fearlessness, fairness, and objectivity of their approach, and by the restraint, dignity, and decorum which they observe in their judicial. So for me, this is ultimately the best way, that judges should not be reacting, to comment. There will always be somebody out there who is going to make tough comments or, criticize even excessively a court judgment. But judges should just, it's treating water off a duck's back, and move on. And they earn their dignity, they preserve, strengthen the dignity of the institution by what their conduct is, and like what this judge said, the quality and the fearlessness, the independence of their judgment. So for me, these are principles, and sometimes it's the internalization of these principles that matter more. Codification, yes, is useful. It's always good to have more clarity. There'll always be a role for a law and contempt, but ultimately what matters, is this kind of value system, which the judiciary must internalize and practice.
Okay, thank you, MP Siva. So the last question for the evening, this is going back to the concept of freedom of expression. The non-censorship of the internet was guaranteed part on behalf of Dr. Mahathir's attempt to encourage foreign companies to set up the MSC. But since then, we ban access to sites glorifying violence and terrorism, pornography, etc. Is it somewhat naive to believe the government wouldn't censor the internet? Surely freedom of expression has its limits and is not absolute. This question I would like to pass on to Wathshlah.
Can't hear you.
Yes, thank you for the question. The reality in Malaysia is that regardless of what statements being made in the past, what promises are being made, we have laws, and these laws are being used to restrict and censor not just internet, but other spaces as well, right? And you're right in the sense that freedom of expression is definitely not absolute. It has its restrictions and limits, and it's provided for also quite clearly in international law. If we look at the International Covenant on Civil and Political Rights, Article 19 talks about freedom of expression and speech. But the same article, paragraph 3, 19.3, basically also talks about circumstances where these freedoms can be restricted. And often they provide two grounds here. One is when it hampers the rights or reputation of others, and second is what I mentioned earlier, on national security or public order, for example, right? And it also provides for what is now known as a three-part test. Are the restrictions provided for in law? Is it necessary? And also looking at the legitimate aim of the restriction. And ultimately also, if we look at how it's being applied, is it proportionate really in terms of the actions and so forth? Right? So international law says something. Of course, our federal constitution, Article 10, which recognizes our right to freedom of speech and freedom of expression, also comes with restrictions. Now the challenge here is two. We tend to ignore the three-part test, or the way it's being applied is not true to the principle of what it intends to be. Or the second thing is we have many laws, or too many laws, yeah, which are broad and very vague in its nature, and it's used to justify attempts of censoring speech or freedom of expression. Yeah. Now, on the other hand, we look at how freedom of expression has been restricted in Malaysia. Yeah. It's, say, for example, the way Section 233 of the Communications and Multimedia Act's been used. Yeah, CMA is it says one thing, but ultimately the most used provision, I would say, would be 233. Yeah, and it is so vague because it has got things that, which is annoying. Yeah, offensive and things like that. How do you define what is annoying? Yeah, what is annoyance to you might not be annoyance to me, but because it's so vague in its interpretation, it's just been so arbitrarily used. Yeah, so definitely freedom of expression in Malaysia, we have the limits, and these limits are seen within the laws. But the challenge is it's just been so arbitrarily used, yeah, that it becomes a tool just to silence any critique or any dissenting voices. So that's the flip side of it, I would say. I mean, I would even go as far as to say, let's look at the 500,000 ringgit fine that's been imposed on Malaysiakini. We ask ourselves then, right, if we had followed the way international law principles are being applied, is it proportionate to the act? Yeah, and I would go on the basis that the mere fact that the federal councils themselves have asked for 200,000, yeah, as fine. So as the 500,000 then proportionate. So these are where I think we need to constantly question. Yeah, yes, freedom of expression is not absolute, it has restrictions, but we need to also challenge the way these restrictions are being used in Malaysia.
Okay. Thank you, Wathshlah. Mr. Stephen, would you like to add anything?
I think I agree with Wathshlah, so she put it pretty well, so I have nothing more to add.
Okay. And 𝗕𝘂𝗍𝗲?
Well, just briefly, nobody, no human rights activist or advocate of human rights would ever claim that freedom of expression is absolute. This is the kind of false arguments that are created to try to undermine human rights. So I think we must be first clear about that. And it applies to a number of other rights as well, including, say, for example, freedom of association, freedom of public assembly. It is never absolute. Yeah. So this is the usual fake argument. Now, so we have to, so in other words, there are permissible restrictions. Some of that will be, which if I'm not mistaken, is stated also in Article 19, defamation. You have a right to speak, but you don't have a right to defame somebody. And if you defame somebody, they have a right to go to court and get their remedy. And likewise, contempt of court is another permissible restriction, but again, it must be a real contempt of court, not, and say, yeah, incite to violence, incitement to racial hatred, racial violence, and so on, statements like that. There is no right to make such statements. Such statements should be treated as criminal acts and prosecuted. So, yeah, but Malaysia, I think I completely agree with Wathshlah. Malaysian laws are littered with excessive, disproportionate restrictions. 233 is a good example, and there are enough examples that maybe we can cite. So that is the long-term battle or struggle for real democracy in Malaysia. It's going to be a process. We're on a transition to democracy. As Stephen said, we are definitely in a better place today than we are what we were 20 years ago, 30 years ago. I still remember, and I'm sure Stephen does as well, the atmosphere, for example, in 1987, when Operation Lalang took place, 100 over people arrested under the then Internal Security Act, and today. So we are moving forward, but we're not there yet. And this is going to be, a process, a transition process. But we need to deal with all these repressive laws and remove them, modify or repeal the laws until we reach what I would call a genuine democracy, a real democracy. That democracy tulen, as we will say in Bahasa. And that's the challenge I think all of us need to do together. The activists, the public, and key people in institutions, and we have to bring this all. We have to bring this process together because our collective strength will always be better than our individual influences.
Okay. Thank you, MP Siva. And now it's thank you for answering all the questions. I would like to invite each speaker to give a brief conclusion to end this talk. First, I would like to invite Wathshlah to give her own conclusion.
Thank you, 𝗖𝗍. I think what we are looking at is the fact that the Malaysiakini decision is symptomatic to what is wrong in terms of how we look at freedom of expression in Malaysia. Yeah, for whatever reasons, the decision was based on or justified. What it creates is a sense where we ourselves are asking, should there be more censorship? Yeah, should there be more restrictions? And the more we start regulating speech, then it may evolve into a space where we would not even dare challenge anything that's being propagated by the state. So we have to be very, very cautious in terms of any measures that are being proposed or being adopted or adapted to regulate speech and expression in any form. Yeah, and again, I would really sincerely like to state my appreciation of the way Malaysiakini is attempting, to deal with this decision. Bearing in mind it has larger implications on both media freedom as well as freedom of expression.
Thank you, Wathshlah. MP Siva, would you like to present a conclusion for yourself?
Well, I thought the last comment I made was already a kind of conclusion because I thought we were wrapping it up then. Well, as I said, I think I'll just briefly sort of summarize the point I was trying to make earlier, that I think to remind ourselves of the bigger picture, the Malaysiakini judgment is one regressive step, in terms of the space for freedom of expression, especially on online publications. But what we have to stay focused on the big picture, the bigger battle, which is in the repressive laws that are being used, and to mobilize responses to them every time somebody is called up to the police station or to IPD, to answer, to be interrogated on so-called offences under the Sedition Act or the Penal Code, just for speaking out. This is where I think all of us need to just keep what do you call it? Calling these things out, exposing them for what they are, speaking truth to power, and just that process that's going to keep the movement forward for reform going. It is like what we said earlier about basically the simple reaction of the public was already a very positive thing. It sends a message to the institutions that what they want and what the people want are quite different things, and that we need to keep doing that, and we will make Malaysia a better place in the future.
Thank you. Beautifully put. Thank you. Mr. Stephen?
Yeah, just a quick thing. I think the people of my generation and people who are older than me, I think we have, if you look back 20, 30 years and all that, we have seen changes being made. I think, yes, the situation today is really, really depressing. We have the emergency, we have, you see, authoritarianism actually making a comeback and all that. But I think, you look at it from a longer perspective, 10, 20, 30 years, you can see that things have changed. I think, we have, we are more empowered to a certain extent. And we'll continue to do that. We have, we haven't actually got to the point where we are actually experiencing real democracy, and I don't think there will be an end point. But we do see some improvements and some changes being made. So I think increasingly, really, the next generation and generation younger than me will have to take up that baton. They will have to, with Undi, 18 and all that, they being able to, those who are 18 and above, now, be able to vote. I think, they will have to decide. And with climate change and all that, really, I think, it's a major issue that the future is in their hands, really. I think they will have to decide for Malaysia, and not just the world, for Malaysia itself, whether, we want Malaysia to be an inclusive, multicultural society, or whether we, whether it should be, we allow politics of fear and hatred to continue the way it is. It is in their hands, and I think it's important that the older generation to be able to impart that sense of struggle, to them, and hopefully, they would take up that fight as well, as what the previous generation have done. I think it's really up to them whether this is the country that they want, and this is the world that they want, really. So I appeal to the younger generation, really, take up that fight, please, because otherwise, we're going to have a, that will be the end of the world, so to speak. So that I think for you, the younger generation, they will have to ask themselves, that really, we cannot, we should, leave the world better than the one that we inherited. That is really important, and let's all do that.
Thank you, Stephen. So that wraps up for our tonight's talk. Thank you very much to Wathshlah, 𝗕ecie𝗂𝗍𝗲, and Stephen. Thank you very much for giving your time today for today's talk. Also, a huge thank you to Malaysiakini for their contribution to news in Malaysia and for partnering us today. So thank you very much to everyone viewing, and have a good night.
Thank you. Bye.